$1 immigration reform, where do we stand on the Senate? Where exactly are we? We know that in the House, we have the proposal, it's passed in the Judiciary Committee. When it comes to Senate, though, it seems that, well, the immigration provisions related to the employment-based are there, immigration provisions are there, immigration provisions are not there. Certain immigration provisions are there, registry is there, but employment is not there. Employment is there, registry is, what's going on?
Well, what we do know is we're on to our next alternative plan for the Senate in order to get some kind of reform for undocumented immigrants. We're looking at options before, creating all these new different classes of ways to get adjustment of status. That's out, not part of the budget reconciliation. So now we're looking at, can we move the date for registry, which is kind of like a statute of limitations where the Immigration Service will ignore violations that occurred several years ago and allow people to adjust status anyways, but we don't know what that date will be. It seems that that provision has been given to the parliamentarian. We don't know if employment-based recapture of the wasted green cards was also provided to the parliamentarian. No one's talking about it. It would suggest maybe not, because that's really not the overall focus of the immigration reform. So we need to keep making sure that we're contacting our senators to ensure that that does get included in the bill, regardless of what's going on with this registry and the parliamentarian.
So at least there is a consensus in item with all the people that the provisions for the registry is definitely there. We don't know about the DACA kits because it's already been rejected. When the employment-based is concerned, though, the provisions related to the essential workers definitely seems to be a problematic thing. But when it comes to using the unused green cards, there is no much objection, because the Senate parliamentarian objection was that you are creating a new class of people in the budget. Budget should be only about money. It should not create, or it should not take off the class of people that should already be there in the immigration. When it comes to utilization of the unused green cards, that's approximately 250,000 green cards, and probably 80,000 that's going to be wasted this year, so approximately 300,000+ green cards. Definitely seems to be not objectionable to her. Then comes the question of having the people who have the I-140 approved and waiting for the green card, and when the prior date is more than 2 years, it doesn't look to be that she has an objection. It's not a class of people that was newly created. These class of people are already there. We are just trying to process them faster than before, and of course we are going to charge them super fees of $5,000 plus $1,500 extra on top of the $1,225 they normally pay, which is good. I mean, people will like, they don't want to wait for that long time. So it doesn't seem to be objectionable, but Senate seems to be working in the closed doors. They're not open. Things are not out, just like the way we have a proposed things in the House Judiciary Committee. We got it released and it passed as it is without no wording changed at all. But when it comes to Senate, though, we don't even know what Dick Durbin has passed through the parliamentarian when she rejected it. At least we know that she rejected on certain grounds, but we don't know actually what was passed in there. So it's definitely a big thing. This is a time for all of you guys to contact the congressmen. Things are moving more drastically in the Washington, D.C. at this point of time than practically I have ever seen in my life, at least as an immigration lawyer in the United States. I've never seen in the parliament. Parliament in most of the other countries work quite differently than that of the United States here, though. The word parliamentarian here is quite different than what we are used to. Here the parliamentarian is actually not elected by the people. She's appointed by the majority leader. What's the situation with Elizabeth McDowell right now?
Yeah, on top of all of this, we just heard that she's going to be unavailable due to health reasons over the next couple of weeks, possibly working from home, but it could delay any action that she takes on the Plan B that she's received, unfortunately.
I've been told that she's, hopefully that she will get better soon, but I've been told that she may not be in action for the next 3 weeks. Her health condition has not been that good. And I'm being informed that it's going to be her deputies who are going to take the action and will give the opinion on behalf of her while she's absent. I mean, this is not a constitutional role that the only Supreme Court justice has to give the judgment. It cannot be somebody else. They cannot rely. I mean, they cannot be here and they cannot be sitting on that place. This is not like a senator. This is not like a congressman. It's an appointed position. The deputies can give an opinion on behalf of her because of her absence and because of her personal reasons why she could not handle the situation at this time. So I think so the deputies are going to act right now. We should still keep the pressure on the House. We should still keep the pressure on the Senate to keep writing letters at this point of time. While this is going on, Emily, I mean, we are at the edge of the year. The year ends in 2 days. And it seems that approximately around 80,000 green cards are going to be wasted. What can be done? I know if they use the provisions in the Congress, they pass it in the next 2 days, that's fine. The 80,000 will be used. If not, is there any other provision that we can?
Well, we've provided sample letters before about trying to ask the Congress people to urge USCIS to use their power to approve green card applications, to use up all of them that are available, and then if they need to, they can go back and revoke after October 1st. The benefit of that is they get to put those 80,000 back in the pool for next year by approving and revoking. The Immigration and Nationality Act makes it very clear that in that situation, those green cards are not wasted. They roll over to the following year. So we do have sample letter that you can send for that as well. Time is certainly of the essence because we are down to the final 2 days.
Final 2 days. If they would do it, we can save the 80,000 green cards going into waste. Into waste. We would really urge all of you guys to write the letters. The drafts have been provided there if you have not already written, though. So, Emily, discussing more on this immigration provisions, though, there is also a lot of things are going on. There's some introduction of the bill by one senator with regards to employment based only, but it doesn't look like it's going to go anywhere. The Democrat seems to be more focused on the children who came here in the United States who are not in documented status. They don't seem to be that interested in the people who already have the working visas, who have been here for a long time. They don't seem to be that interested. Any reason why the Democrats are not interested in them?
Well, I think it's more that, over decades now, the Democrats always want comprehensive reform and the Republicans want more of the piecemeal reform. So it's not that they're necessarily against some employment-based provisions that would improve the situation, but they're not willing to do piecemeal legislation of only that. So it's all or nothing with the Democrats. They've constantly been that way, which makes it very difficult to get anything to pass.
Yeah, when you ask the Democrats, they will just ask, why don't you first pass the DACA, and then we'll go to the other things. The Republican says, well, why don't you go to the border? Let's restrict the border. It's definitely a thing. But let me quiz you, Emily. Who has a majority in the Senate?
Well, technically the Democrats do with,
it's
with our Vice President.
51 votes to 50. So Democrats have the majority with the Vice President being a Democrat. Who has a majority in the House?
House has Democrats have a clear majority in the House.
Which party does the President belong to?
Democrats. For sure.
Why can't they do anything?
Yeah, it is all based on the filibuster in the Senate, because normally any law to pass out of the Senate, you have to have 60 votes to break the filibuster. And that's why we're moving towards the reconciliation option, because in that situation, you only need a simple majority, 51 votes, to get this bill passed. But yeah, it is all based on basically one senator can block an entire bill. And we've seen that happen time and time again. You saw it with the Fairness for High-Skilled Immigrants Act, removing the per-country quota. One senator puts up a ridiculous excuse for why it shouldn't go through. We work through that problem and then get that senator on board, and next time it's a different senator. And the only way to stop that from happening is to have 60 votes, which we can't seem to get enough people on the same page for that.
Emily, I may not have studied the constitutional law in United States law school, though. I took the bar exam, of course, but You took the constitutional law. Is this filibuster there in the Constitution?
No, it is not.
So where does it come from? Why is these people, I mean, why is that at the time when they appointed the Supreme Court justices, they removed the filibuster? At the time when they did the tax cut at the time of President Trump, they removed it. Why is that they needed it right now?
They don't. It's ultimately in the Senate rules, which the Senate has control to change the rules. They can change the rules whenever they want to.
But the Constitution does not have the role, there is no person by name parliamentarian in the Constitution. There's nothing called filibuster in the Constitution. It's practically is giving a veto power, which is only given to the president, which I understand. I mean, even if I like the president, I don't like the president should be given the veto power. So it looks like every senator has a veto power in the United States, and they don't want to give it away with it. That seems to be ridiculous. And I think so it's unconstitutional. The only problem is we cannot challenge this in the court because it's their internal rule. It definitely has become a handicap now. Even when it was, a Republican had a majority, a Republican president was there, I never liked the filibuster because I believed in that it's not what the Constitution has granted them the power though. What we call is delegatus non-delegate, the Latin word, I forgot it right now. Most of the law that I learned was in Latin because back in India, they only teach us more Latin words then. The Constitution has delegated the authority of passing the laws to the Parliament, to the Congress though. They cannot just give it up to the next person though. That's really not fair, not good. I think so we should urge the Democrats to bypass the parliamentarian and get these things included if she doesn't fall into line. If she agrees, that seems to be fine. If she doesn't agree, then we should have them bypass these things. So, Emily, at this point of time, it looks like Democrats are trying to convince the parliamentarian to the greater extent. But I also believe that they are going to keep piece by piecemeal passing it to her. Hey, will you approve this one? Will you approve the employment-based unused these things? Will you approve these filing the adjustment of status when the priority date is 2 years backlog? Now, let me explain you guys in the whole context of the law though. If you look into it, the major discussions that's going on, look into the Fox News, look into CNN, look into CBS, look into all the major news channels though, they are not even discussing anything about employment-based as much as you think so that. There are not many channels. A lot of people are asking this question. Where do we get the information about the employment-based daily information? Because their lives are hanging there. Where do we get them? And there is nothing like that. Because if you go to CNN, they're going to discuss about the cap reconciliation bill. Of course, they're going to discuss about the registry. They're going to discuss about the DACA kits. They're going to discuss about other things. When it comes to the employment, there is none there. And the senators are not publicizing the information properly. They're not giving up the information just like the way House has given up the information to us. We have a very good congresswoman that is a very good advocate for us, Joey Lofgren, who also happens to be at this point of time the Judiciary Committee chairman for the House though. We definitely got our things very well done in the House. I mean, I cannot ask any more than what she has given to me. Definitely when it comes to the Senate, we don't have those kind of champions. We don't have the Arizona senator like McCain. People like that are not existing. We have Senator Grassley, even though he's not a majority leader in there, his influence is very much in the Senate. We have anti-immigrants there, very much ruling there. Senator Durbin doesn't seem to be that favorable to the employment-based immigration as much as he is for the DACA kids, though, the kids who are underage, though. At this point of time, we urge all of you guys to become your own advocates, and you need to write the letter to the congressman. You need to raise, look, how many rallies are getting happened? Do you see any rally for the employment-based? None, zip. I say that, I mean, in the animal kingdom or whatever it is, the baby that cries the more will get more fed and will get to survive better. The baby doesn't cry that much. They don't. I mean, the mom only gives food to the baby that cries the most. And we are the people, oh, you know, you're all comfortable, you're doing good, but if you don't voice, if you don't write letters, if you don't contact the congressman, if you don't contact the senator though, we may happen to stay here for a long period of time. I will tell you the truth though. When I and Emily published an article in 2018, we published an article saying that how long it takes for a person to get a green card from India if you file. And we published an article in 2018, in February of 2018, we said it's going to take 108 years to get the green card though. Now, having said that, there comes an institute called Cato Institute, very reputable institute. Me and Emily give very high respect to that institute. But that institute said that we are wrong by 42 years. They have given clear description. They practically use the same formula that, of course, they have much better data. They said it's not 108 years, it's 150 years. And that's how long it's going to take for the people to get the green card now. Of course, they did not assume that people are going to die, just like we didn't assume. We always think our clients are going to live forever. And same thing Cato Institute did though. Obviously, that's how long it's going to take. Obviously, we got some opportunity in 2020 October, that's 2021 and 2022, and we have seen the wastage of the green card right now, even though we got this opportunity to cut down the time on that. Obviously, this COVID is not going to be there, hopefully not. So for the people going forward though, if these bills are not going to pass, if we're going to go with the existing bills what we have right now, it is going to take a long, long time. Hopefully so, when you are 110, maybe with this modern technology, you may live that long, you may be able to get the green card though. This is the crucial time for us to contact the Congress, put a pressure. All we can do in this democratic system is to write letters and if needed to do the rallies though. Obviously there are some faults in the democratic system. There are faults in every system. Democratic system has its own, presidential system has its own faults. There are many beauties of this country. Democracy has many, many beauties. Presidential system has many, many beauties. But there are some problems here, especially when it comes to the Congress, which we call as Parliament. Outside the United States, we call it as Parliament. There are some faults here in the United States. They don't get anything passed. They'll go around the circle, go around. They've been only paid for one thing and they've been elected for one thing, is to pass the law. That's the exact thing what they don't do. We need to put a pressure on these people to keep writing letters. Have your community people approach, not just yourself. When you go to the language community organizations, which are very powerful, like the Telugu Association, Hindi Association, Marathi Association, Tamil Association, Gujarati Association, we need to put a pressure on these people because, believe, Indians are one of the highly earning income people compared to any other race in the United States and compared to any other national origin. Indians are making a lot of this money though. If these people can use the pressure, you can have these organizations put a pressure on the congressman or the senator, it definitely works. These people have already climbed up the ladder. They don't understand your 485. They don't understand what you're doing. But you have to go to your own community people, explain them, look, buddy, you got the green card in 2 years. That's not how long it takes. It takes 100 years for me to get the green card. There is a discrimination. You have to explain them because these people are funding the senators. If they write a letter to the senator, it works much better than when you write. So please contact your community people so that they can contact them. Any other suggestions that you can give, Emily?
Yeah, just don't give up. I think that's the best thing. What we've seen over decades with the Dreamers, they keep at it. They've been advocating and they don't stop advocating. We see time and again when immigration reform is talked about for employment-based, there's a lot of activity and talk about it when it's happening, and then as soon as things don't work out, everyone just gives up. And then we wait until someone else tries something. And it could be years before we get another chance again. So even if the reconciliation doesn't happen, don't give up because we have to have some kind of reforms. The system is clearly broken. It doesn't work. And you are the best people to help get that fixed.
I would rather be optimistic and be wrong rather than being pessimistic and be right. This word I'm copying from Elon Musk quotes. I would repeat again, I would rather be optimistic and be wrong rather than pessimistic and be right. So please keep the optimism up and keep the morale up and keep writing the letters, guys. That's the only way that I can think about. Questions that are coming up, Emily, on the registry though. What is registry? Registry is if you are present in the country before January 1st of 1972 and you have been present in this country, you have been residing in this country though from January 1st of 1972, you can just file the 485 application. You don't have to pay any extra super fees at this point of time. You can directly get the green card though. What they are wanting to move is that they want to move that date from January 1st of 1972 to January 1st of 2010. That's, remember, we don't have the inside information. It's a very secretively what the Senate is doing. That seems to be the consensus among all the people, that January 1st, 2010. So if any of you guys who have been living from January 1st of 2010, maybe if you have a lease agreement, try to keep it. Any documents, go check it around. Try to keep the documents, medical records, travel records, lease agreements, credit card statement, bank statements, driving licenses. All these evidences are the ones which we normally show when we apply under this called registry. There are some rumors that it may be 2001 instead of 2010. There are rumors up to 2015 also. But it looks to be somewhere between January 1st of 2010 and January 1st of 2011. Now, even if you have traveled outside the country for a brief visit to India, it does not interrupt. You are still eligible to get the green card. People have this question, do I have to be undocumentedly present in this country for being eligible for the registry? No, you don't have to be. According to the current law, if they're going to just extend that though, this will be applicable for the people who are documented. This will be applicable for the people who are undocumented. Unlike the DACA, which the dreamers that we call it, it's only allowed for the people who are undocumented, not for the people who are documented though. So this one is for everybody, for everybody who is legal and who is not legal, and who have been present here from January 1st of 2010. This is 2010 and 2011. I'm making it up, guys. But Jitin is asking the question, can the H-1Bs also be eligible for the registry? Yes, absolutely, you can be. I mean, if the registry date has been moved all the way to January 1st of 2010, and if you are there on January, you're residing here from January of 2010, even if you have visited a couple of times to India, which, you know, I know, Jitin, you might have done it, that's fine. You are still eligible to get the registry. That is how it reads, unless they drastically change what the registry thing is.
Yeah. All right. So other issues that we have going on in immigration right now is this potential for a government shutdown.
Oops.
That could be happening September 30th. It's a perfect storm here right now. So this is the funding of the government, funding all of the agencies. It's supposed to be starting from October 1st. And it ends on the following September 30th. So this current year's funding runs out on September 30th. The government has to fund the government for next year, and that process is not going well at the moment. We have, the Senate was trying to pass both a continuing resolution, which would basically keep the government going until about December, while they kick the can down the road, and we talk about this again in December. At the same time, they're trying to include the debt ceiling limit, which is another problem going on with our government right now. That proposal was, because of the filibuster, Republicans were not on board. They shot that down, so now the Democrats have to come back with just a clean bill of just the continuing resolution for funding. But if that doesn't get passed by both the Senate and the House before September 30th at midnight, the government shuts down. What kind of immigration consequences can happen from a government shutdown?
One thing is that the LCA, the Department of Labor, might shut down. So that means that any LCAs that are in the pipeline will not be approved. We may not be able to file any more LCAs. That means that any new H-1Bs we cannot technically file unless the LCA is there, unless the USCIS will come up with an exception. Labor certifications, there will be more delay. We cannot file it. We cannot get it approved. That's another problem we will be facing. When it comes to the 485 interviews, though, we should be fine with the 485 interviews. Because it's a fee-based USCIS thing, you will be fine. You will not have any problem in going for the interview and getting a green card, though. The SAFE database, the database that allows the state departments, like for example, if you go to the Texas driving license and you want to get the driving license, since the SAFE database is going to be closed, you may not be getting the driving license. So these problems will be coming up when the government closes at this point of time. This is the information we have been informed recently, 2 days ago. So if there is anything, we will update you in the next week. Anything else, Emily, that I didn't cover?
Yeah, other areas of immigration, Department of State, if you're going for your visa interview, visa stamping, all of that should continue as is because you do pay a fee, the visa application fee for that. What else? CBP, if you're flying into the U.S., port of entry, they should all be operating normally. They're considered to be essential, so they don't stop working in the event of a shutdown. So it's really mainly going to be people who have to file an H-1B extension and cannot get the LCA in time. In previous years, when we have been through a shutdown, when the government reopened, USCIS usually would announce a provision that would allow the late filing of certain H-1B extensions. This also impacts H-1B1 and E3 because all of those require an LCA. They would allow the late filing of those applications if it was due to the shutdown because you could not get your LCA timely. So hopefully they would make that consideration again. Hopefully none of this is going to be a problem. Hopefully we'll at least get this passed through December, but we may be having the same conversation in December, which happens to happen every couple of years.
Emily, the Texas Service Center has become a nightmare for the people. And when we file the downgrade applications, we send the address to Louisville, Texas. Most of them ended up in Texas Service Center. Some of them ended up with the National Benefit Center with MSC as a date, which we see that statistically most of them got their green cards approved that went there. Now the million-dollar question is, if my 485 is pending under EB3 right now, my I-140 is not approved or approved either way, and my EB2 date become current, should I file the 485 right now?
I'm not a big fan of that because it doesn't, you basically are putting yourself in the back of the line. And so all of the waiting that you've done to this point is over with, and you start a new round of waiting.
There are rumors, Emily, that the people filed in July of 2021 got their green card approved. Rumors, though
I
not.
haven't seen any of that.
There are rumors, of course. Here is the issue, guys. If you have already filed the 485 application, if you file the second 485 application, you can't use, so remember that, the EB2 and EB3, the job is the same though. The classification might have changed, but job is the same. Since the job is the same though, they will ask, you will have to withdraw one of the application. You can't continue with the same job with two 485s. Now, they will, even if you don't withdraw, the USCIS will come back. They will force you to withdraw one of the application. Look, you have two of them. Which one you want to proceed? At that point of time, you have to withdraw one of the application. That will take time. That will take time. A lot of people, some people ask question, Rahul, are you worried about the money that I'm going to spend? No, I'm actually not worried about the money you spend. I'm not that concerned about it. It's okay if you spend about extra $7,000 to $10,000 for your family or $5,000 to $10,000. I'm fine with it because I was an immigrant before I became an immigration lawyer. I understand. When my colleagues were having debate about $5,000 extra filing fees, I told Emily, forget it. My guys will pay. Don't even worry about it. Don't even think about it. They are willing to spend that $5,000. I assured them 98% of them will spend the $5,000 without asking any question if they are allowed to file the 485, especially in the employment based. Now, having said that, coming to the point, we are not concerned about your money a little bit. If we feel that at this point of time, we may change our opinion later on, though at this point of time, we don't feel that it is going to benefit you. That's the main thing, though. Because when you file, as Emily has pointed out, you're at the back of the line, and there's another problem. You will have to withdraw one of the application. There's an extra RFE issued, either on this one or on this one. So either way, there will be a delay. This is where we feel is a problem. And another thing is that for you to file a 485, you definitely must not have used the EAD that you got through the EB3. So at this point of time, we are not recommending it. We'll be closely observing how the things are going around, and we may change our opinion later on, but at this point of time, we are not recommending filing the 485 application again if you're already in the line, though.
All right, time to get to some questions. We've got a lot coming in today.
Are the essential workers in the bill? At this point of time, though, the Senate version, I can fairly say that it won't be there in the Senate version of it. So that provision may be out of all the provisions. That's the least preferred thing, because even the employment-based preference guys, let's give up on something to get something. So may have given up on the essential, because it creates a new class of people who were not eligible before. Like the people who are priority date is 2 years, they're already there. The class is not created newly, which is objectionable by the Senate parliamentarian. So that is out right now.
AJ wants to know, why have we stopped doing H4 EAD litigation? It's a really good question. Ultimately, it boils down to not providing the benefit to the clients. Our whole goal in the litigation is to get you your EAD faster, and if that's not happening, we're not going to keep
Can you
filing
explain
in order to do
how
that.
and why it happened and why it did not happen later on, Emily?
Yeah, COVID plays some role in this, but also on top of that, we have a different administration. We started doing this under the Trump administration. With the Biden administration, they're taking a very different strategy in responding to these lawsuits. They are basically trying to delay any way they possibly can, so that a judge never actually gets to make a decision saying that this is an unreasonable delay. So they will try to change the venue, they'll try to split up cases, they'll try to move them from one court to another. They're just bouncing everything around, filing all these different motions simply to delay. And the longer they delay, then it doesn't help you get your EAD any faster. So we're just not able to provide that benefit anymore. I will say this. Our firm, Stephen Brown, along with Jonathan Wasden and American Immigration Lawyers Partners, have just filed a new class action lawsuit, basically trying to get USCIS to agree that both H4 and L2 EADs should be eligible for automatic extension when you file a renewal. They should not be treated any differently than GC EAD or the STEM OPT EAD, where they get automatic 180-day extension. That would free up so many resources of USCIS. They could take their time in adjudicating those and allow you to keep working while it's pending. So that has just been filed, including a request for preliminary injunction, asking the judge to say, look, this policy is not correct. You need to reverse course and start providing an automatic extension. So hopefully we will see some traction on that.
Emily, if I am not part of the litigation, will I get the benefit from it?
Yes, that is the great benefit of class action lawsuits. As long as your circumstances are the same as the class, then you get the benefit without being an individual named plaintiff. So we tried to have that class of applicants cover as many people as possible, so that as many people can benefit from this as possible.
Marceline Joseph has a very good question. Will registry help the GC backlog? Yes, it does. One of the reasons why, I will explain you. If the registry is moved to, let's say for example, January 1st of 2010. So practically all those people who are on January 1st of 2010 will go to the 485 application, not through the employment based, but through the registry base. So a certain class of certain number of people will be out of the line. They were standing in the 485, they were standing the priority date of the employment based. All of a sudden, some of the people will go to a different line, because that line is much faster, much easier, and not much bureaucracy is involved in it. All you need to do is that show that you're present here on January 1st of 2010 and certain other documents. No employer required, no 485J required, not much things are required for him. So they will go in that line. Given an option, if I were to file a 485 application for my client in the employment-based category or registry category, I'm going to go with the registry category because he doesn't need employer. There's no conditions, preconditions or after conditions attached. So definitely they will be out of line. It will definitely help the overall backlog, but we still want to have our own employment provisions there. Don't give up, guys. Be positive. Try to strive on that.
Kier from Facebook wants to know, I recently learned that USCIS is reconsidering earlier denied decisions for the EB2 to EB3 downgrades for physical therapists. Is there any way to reach out to USCIS after the appeal time has passed and ask them to reconsider an earlier decision?
Didn't you appeal recently?
Yes, you are correct. So we have been able to successfully appeal denials that we've received and gotten those approved, and I am hearing others are getting them reopened on their own. If you don't want to wait for USCIS to reopen on their own, I would file a late motion to reopen, reconsider. Even though it's late, the USCIS has the discretion to accept a late filing and still treat it as a timely filed motion. At least that should raise their attention to the fact that they need to reconsider your case because it was one of those denied cases from the Schedule A issue that we were having.
Ishwar Shankar, he's the EB3 rest of the world case. He resides in Houston. Welcome, Houstonian. But the case is moved to Harlingen per Emma. Why does this happen? This is a good question. What he's telling for the rest of the people is that his district falls under Houston, though, for the 485. Why is his 485 application moved to Harlingen, which is almost like 300 miles from here? There, Ishwar, what's going on is that if there is a lot of load of the 485 applications in one particular district, though, they are moving some of the files to a different district to adjudicate it. At the time of Trump era, though, they have already said that the 485 interviews could happen at a different district than what you are residing at. We haven't seen any of them happening, though. They're just moving they're doing all the back end work and sending it back to Houston or approving it actually. So it definitely is a good move. We have seen very significant number of cases that have recently happened. We welcome that, and most probably that may reduce the amount of time that it takes to adjudicate the application.
Nikhil wants to know, once an H-1B I-797 is approved, is there a timeline you should join the new employer? What if I want to join after 3 months of the approval? So I'm assuming this is an H-1B transfer situation. Technically, no, there's no timeline that you have to join that new employer. You technically never have to join them if you change your mind and want to stick with the original employer. However, there are some companies I've heard of over the years that are concerned with potential wage liability for the LCA compliance regulations that say that they have to get you onto payroll within a certain amount of time after the H-1B takes effect. Otherwise, they could be subject to having to pay you back wages, and for that reason, they will withdraw the H-1B if you don't join within a certain amount of time. I don't think that that is a mandatory requirement. If you want to delay your joining that company, they just need to keep documentation in the public access file or in their personnel records that confirm that that was per your request. It was not an unlawful benching of the company saying, no, we can't hire you right now because we don't have a position for you. So as long as it's the employee's request and the employer is okay with that and it's documented, you can wait and join later, and as long as you're continuing to work with the current employer.
Questions with regards to the registry continuation of presence in United States. Do you need to be continuously present from the time of registry date until right now? This question is coming from Nikhil. When they mean to say continuation of presence is that you must have a residence in United States. You must be residing in United States. that doesn't mean that in the entire period of 12 years, you never left the country. No, you may have left the country for 1 month, 2 months, visiting India or going out on vacations to Mexico or Canada or whatever locations, visiting in India for a couple of months and coming back. But if you're maintaining the residence here in the United States, that definitely is going to cover, though. It doesn't mean that the entire 11 years you're completely only present in this country, you never left the United States. That is not true. Even if you leave the country, briefly though, but if you have left the country and stayed in India, for example, for about 9 months or 10 months, that definitely breaks the things. Anytime if it's more than 5 or 6 months, you definitely are at a risk of not getting into the registry as we read it right now, unless they change it.
Vikas has an I-140 approved in EB2 with employer A with a 2015 priority date, just got his perm approved with his current company, and wants to know, should he file the I-140 in EB2, EB3, or both, because he's porting that priority date. And the perm is destined for EB2. You know, we say time and again, we cannot accurately predict these priority date movements. You know, just based on looking at the number of approved I-140s per year in the different categories from India, it seems that there are many more I-140s filed in EB2 compared to EB3. So perhaps that means EB3 could move faster once it starts moving again. But we could be completely wrong. We don't know how this spillover is going to happen if Congress changes things. So I guess if your employer is willing, I would say file both. Otherwise, if you have to choose one or the other, I can't make that choice for you. All I can say is that, you know, we just don't know. So if you can file both, go ahead with both.
Kashyap has this question: can I travel to Mexico in December and do automatic revalidation? Have a stamped F1 visa and my passport valid I-94 until 2024 on H4. Absolutely, you can. I just want to explain to people what an automatic revalidation is. That if you have a valid I-94, even if you don't have the stamping for that particular thing, in this case for Kashyap, he doesn't have a H4 stamped in the passport though. If he goes to Mexico or Canada and stays there for less than 30 days, and he doesn't apply for any visa stamping, I repeat again, he does not apply for any visa stamping, he can come back into United States. It's called automatic revalidation. We're going to have a separate video on it in a couple of days and release more about what this automatic revalidation is. But yes, Kashyap, you can.
Ojas has an unusual situation. USCIS denied the 485 that was filed last October, saying the priority date was not current when it actually was.
Oh yeah, and then they actually said that it's some of the people that I've heard is that it's a family-based immigration visas are not there. We have seen these kind of things very in the recent 30 days very many times, Emily, in my conference calls that we conduct. We do have a conference call every single day, guys. So if there's a link there that is provided, you guys can come there and ask the question. Live questions will answer it. Yes, Emily, a lot of things are happening.
Yeah, so what are your options in that situation? I think you have 3 basic options. If you've continued to maintain your underlying non-immigrant status, you could choose to refile the 485, assuming the date is current.
Wait. This is the 485 application that guy already filed.
Right, but it's been denied. I'm just giving all the options.
Oh, denied? It's a denied?
Yes.
Oh, I thought I got confused. I thought maybe they just sent a letter saying that your date is not current.
Oh, no, he said his was denied.
It's denied?
Yeah.
Okay. Denied after they didn't issue an RFE and denied?
I guess not, I don't know.
That looks very hard.
Yeah. Not unusual. I mean, it happens.
It happens.
USCIS makes errors on these sorts of things.
Sorry, go ahead. I'm sorry,
so
Emily.
one option would be to refile if you've continued to maintain your non-immigrant status. Another option is to file an MTR. You don't have an option of an appeal because only a 485 denial cannot be appealed, but a motion to reopen or reconsider can be filed, clearly with clear error. Once that motion is accepted, it puts you back in as if the denial never happened, if they agree with you. And the other option is litigation. That works wonders.
That works
on
wonderful,
these kind
actually.
of silly.
Yeah.
I would say litigation is probably your fastest option, but it's probably more expensive as well. But you do have options. I'm sorry to hear that.
Yeah, but if you want to contact our office, Stephen Brown is a proper person for you to contact the litigation. In the continuation of that, Emily, that we have received a lot of letters saying that, hey, we are not adjudicating your application because your priority date is not current. That is happening even if the priority date is current. In that case, though, I would suggest that you can contact the USCIS Ombudsman. Now, you can Google this, and there is a contact over USCIS Ombudsman for case assistant. That's one thing. Contact the congressman. That's another thing. The third thing probably is also to raise a service request. The fourth thing, which is expensive but may have a good result on that one, is a litigation. Court litigation might work very good on that one. These are the things, because if it's clearly an error, though, where, I mean, they're just stupid. They don't look into their own visa bulletin pages. Definitely, it's worth going to court litigation, because you want to show to the judge how stupid these people are, and they don't want to go to court, and they would like to get your case adjudicated so the judge never sees what's going on.
Ilongo is planning to move to a different state. His I-140 has been approved for over 180 days. His employer is going to be staying in the same state and location, and he wants to know, do I need to reprocess the I-140 petition? Depends on a couple of factors. First factor, have you filed the 485? If you filed the 485 and it's been pending for at least 180 days, you can use AC-21 to move your job location. Even though you're not changing employers, you can move the location of your job to any location anywhere in the country under AC-21 without having to reprocess anything. Just submit a Supplement J form. If your 485 has not been filed, then it depends on where the job offer is, the future job offer for the position you'll take when you receive your green card. If that job offer is also moving, then your labor certification at the old location is not valid for the new location. You need a new perm and I-140. If the job offer at the original location is still there and you're just temporarily moving and you'll come back when you receive your green card, then no action would really need to be taken.
Harry has this nice question, Emily, that I want to trouble you. He's saying that if the government shutdown happens, can the USCIS say that we can't pull your labor certification in approving the I-140? Where did you get this idea?
So don't give them any ideas.
They may make an excuse. I mean,
well,
they have.
If they're getting the I-140 or the labor from the DOL.
They already have it in their system. When you file a Freedom of Information, they already have it. But yeah, you're right, Harry. They may make an excuse, especially for the premium processing. They may say, hey, we can't get the labor approved, so we can't get the. They may make an excuse. I hope nobody listens to us and nobody listens to what Harry has questioned. Hopefully so. Especially the USCIS. They have the labor certification in their file. Your company filed it before you filed it before. That's how they approved the I-140. But they may make an excuse. You're right on that. There is a chance for it.
Guan wants to know, for AOS filing after PERM, can I try to avoid the Nebraska or Texas Service Center by avoiding concurrent filing? That is a great question, and I've been experimenting with that. So yes, we do know I-140 and 485 filed concurrently goes to the Dallas lockbox, so you're likely to end up at the Texas Service Center, which is taking forever to process everything. So yes, if you file the I-140 by itself, once you have that receipt or get that approval and then turn around and file the 485, then it goes to a different address where it could end up at the National Benefits Center, which seems to be the best option. Doesn't necessarily mean it will work out that way, but that's one way to at least try.
So let's discuss more further. Emily, even in cases where we filed in Louisville, Texas address though, if when we have filed with the I-140 though, it most probably ended up in Texas Service Center. But when we did not file with the I-140, just plain, in the same address though, it ended up all different places.
Mm-hmm.
So they have a better chance if they file without an I-140. USCIS is not shutting down, Manish. They are going to work though. What we are more fearful is the LCA and the I-140 approvals, especially for the downgrade applications. That's what we are worried about. Not in general, USCIS is not shutting down because it's a fee-based application. Ganeshan has this question, is there a no country quota for registry? No. No, there is no country quota for registry. Thankfully, no. Thankfully, no. Can you file derivative applications via registry-based application? Good question, Karthik. Yes, you can. The derivative doesn't have to be residing from January 1st, whatever the date they might have given. I'm just fixing a date of January 1st, 2010. Please don't shoot me if that doesn't happen, okay? I'm just making up the date right now. So if you are there on January 1st, your wife has joined in 2012, she can be added into the application.
Mency wants to know, I recently got my change of status from F1 to H4 approved, have the valid I-94. Can I travel to Mexico in December and come back to the U.S. within a week without the H4 stamp using automatic revalidation? Yes, automatic revalidation does allow you to travel to Canada or Mexico for less than 30 days, not get the visa stamp and come back as long as you have a valid I-94 attached to that I-797. It does also work in the event of a change of status. So it works for extensions where you received the I-94 after the extension was approved, as well as change of status.
Question from Birinder Singh. I came here in USA on B1 visa in 2009 and H1B in 2010. I'm assuming that you came in 2009 and you converted into H1B in 2010, you definitely are fine. Now, when you're telling you came back again in 2010 though, that means that you left the country, you stayed for a long time outside the country and came back on H1B, and that is probably in October or November. So that may have a problem, but if you have converted from B1 to H1, you should be fine. Sound treatment from YouTube as this question. Many people are receiving I-693 medical reminder letter. What does this mean? Is it a good sign? Absolutely, it's a good sign. If you have not filed the medical, we have told all the people to file the interfiling. And I see some of the people saying thanks for our suggestion. We got a lot of people saying that they got the green card without getting any RFE and medical reminder letter because they interfiled. A lot of lawyers, most of the lawyers said don't interfile. We said go ahead interfile, and it worked for most of the people. I didn't say that it worked for all the people, but very good number of people. In fact, you can see some of the messages here that got the green card. Thank you, Lata, for telling us for the feedback. Yeah, the medical reminder letter definitely is a very, very good sign. Respond to that and send the address, what is there. Send them the medical thing to the address which is provided on the medical reminder letter. We are telling our clients that, hey, send it by yourself. Don't send it to our office. Because it takes 1 day or 2 days for us to send it back. There is extra cost involved. Why don't you just send it out? That's what we're telling. If it's anything else other than medical, though, we strongly recommend people don't respond to those RFAs without going through a lawyer.
Harry wants to know, how much time does it take for NVC to schedule your EB green card interview after you become documentarily qualified, and where can I find this info? Well, first, the info is not available anywhere, so you won't be able to find it. And it really varies by consulate, because the NVC is kind of a national clearinghouse, or I guess a worldwide clearinghouse, where they schedule the green card interview for all of the different consulates based on what availability each consulate has. Some consulates may have more availability than others, so it really varies greatly. There's no rhyme or reason to it. I've seen some within maybe 2 months, others more like 6 months. It could be anything in between.
Deepak Agarwal, my prior date is not current, but still received an RFE for medicals. Even after 2 months submission, status says RFE request sent. USCIS's case is on hold. Please suggest. Try to chat with Emma on it. We're seeing a lot of problems. Even though when you responded to the RFE, raise a service request and see if they will respond to it. If that says that they received the RFE, that's fine. The other thing, Deepak, maybe you may want to call that number and then it takes about half an hour to 1 hour for you, and get to them and see if they have received RFE. Now, if all these three things are coming negative though, I would rather want you to submit the medical again.
Praveen says, what happens to the EAD if the final action date retrogresses after 485 filing? So if you already have your EAD, it continues to be valid and you can keep renewing it as long as your 485 is pending. It does not matter whether the priority date is current or not. If you have not yet received your EAD, you will still receive it. They don't stop processing EADs in the event the date retrogresses. You're eligible for the EAD simply by having a pending 485, regardless of whether your date is current, regardless of whether your I-140 is approved. So no impact on the EAD when dates retrogress.
Naveen saying he contacted Stephen Brown on a visa regression letter. I'm assuming that your priority date is current. If that's so though, please drop an email to me. I will have a discussion with Stephen. We had a discussion and we'll get back to you on it. You can send an email to info@rnlawgroup.com, Naveen. I'll look into the matter very thoroughly. If for registry, we already filed 485 last year. Do we need to file again? If you are eligible, can we amend the existing 485? Oh, that's a very tough question.
Yeah, I doubt it.
Yeah, you can definitely file one more 485, but I'm not sure it's worth for you to file it. Unless there are some deficiencies in your current 485 application though. And the priority date is now backlogged for you, the final action date, I would definitely not be willing to file your 485. But if your priority date is backlogged significantly, and let's say, for example, if your priority date is December 2014, yeah, I may be willing to file a new 485. I would not be using the existing 485 and transfer it to this registry. I would file a fresh 485 for you, Kiran.
Tom says the primary applicant has been approved but waiting for an RFE for a derivative, and he wants to know, do they allocate the visa number for the derivative if the date retrogresses before we respond to the RFE? We don't have a ton of visibility into when exactly does that visa number become allocated to an individual person. I think that if not all of the documents are there, it's less likely that the visa number has been allocated. Usually it's after they receive everything and are actually ready to adjudicate. So most likely they didn't, but that doesn't mean that they haven't. Sometimes they do that, do things out of order.
Emily, I want your attention on one of the things which is more important with regards to a lot of people are trying to understand, when does this registry, or when there's this budget reconciliation, when does this immigration bill have to be passed? Is it September 30th deadline? Can they go beyond? If so, at what time can they go? What's the issue?
Yeah, so the reconciliation, there really is no actual deadline. It just needs to be done during the current congressional session, which goes until December 2022.
Which is 1 year and 3 months now.
Yeah, so we have over a year for that to happen, but the window is certainly closing because they want to get these things through before midterm elections, which are going to be next November, and that means they're going to start campaigning well before next November. And they don't want to have blood on their hands if someone, one of their constituents doesn't like what they do. They don't want to have that happening right at the time when they're trying to campaign to be reelected. So those midterm elections and that campaigning process really eats into several months of our window to get this through. So it's going to have to be within the next couple of months here.
Yeah, because once the election time comes in, they're fearful. Santosh has this question: will I abandon 485 application, downgrade, if I leave USA without advance parole? If you're planning to come back on H1, H4, stamping though, if you don't have an advance parole, if you come back on H1 and H4, you're fine. L1 and L2, you're fine. Any other visas, if you file a 485 application, you're planning to leave and wanting to come back without advance parole, you need to contact your lawyer. Suhail has this question: can we file AOS based on cross-country chargeability when spouse is not in the US? No. If your spouse is from the rest of the world and you are from India, hopefully so, That's the reason why mostly cross-country chargeability we use. You cannot file 485 without your wife, because the basis for cross-country chargeability is your spouse. If you don't have a filed application, you cannot file by yourself.
Let's see. Latish is planning to file the H4 EAD for his wife, and the processing time seems to be too long. Can she travel outside the country while her application is pending? Assuming she already has the H4 status, and she's just filing a standalone EAD, she has to be physically in the U.S. on the day of filing. After it's filed, yes, she can travel outside the U.S. without having any impact on the EAD application.
A lot of people got the green card. That's good. The questions that are coming with regards to some of the people who got an EAD, can I maintain the H-1B and go for stamping? Wow, why do you want to do that? Ashok, I don't know how to say that. I personally don't like to maintain the H-1B. There are some deficiencies. Obviously, I cannot guarantee that, okay, you will be perfectly good. There are some deficiencies if you let go the H-1B, but there are some deficiencies if you keep the H-1B though. There may be FDNS visit that might create some trouble for you. If you change the location, that will create a problem for you. For your travel outside the country, that will create a problem for you. You go for the stamping, it creates a problem for you. H-1B has a lot of issues. They have to maintain the salary. A little bit with regards to the job changes though, I mean the GC-EAD has more flexibility as compared to the H-1B. So I personally, I will give up my H-1B if I were you. I don't want to feed the immigration lawyers unnecessarily. I don't like them actually, you know. I don't want to keep them in my life for a long period of time. Even though I am one of it, but you don't want to keep your immigration lawyer very busy. Just because you're paying more money to a lawyer doesn't mean that you're getting the proper thing though. Do you know how much we charge for GC-EAD? I don't want to mention it, we don't mention it. It's very less money. Do you know how much we charge for H-1B? A lot. H-1B has a lot of filing fees. H4, and you have another problem. H-4 EAD is a lot of delay. If the H-4 EAD is not approved, she cannot work. GC-EAD extension is once you file the extension, even if the GC-EAD expires, you can work for a 6 months period of time. So there are so many advantages, and the filing fees for GC-EAD and advance parole is $0, zero, really $0. You can't believe me, it is the truth, $0. But H-1Bs, when you transfer the company, it may go all the way to $6,000. So these are all the minus points that you have. I personally would not like to keep the H-1B. There are some minus points of letting go H-1B, but there are more minus points of keeping H-1B. So you have to pick your poison.
All right, well, I think we're out of time for today. Thank you for joining us, and thank you to everyone who's reporting that they've received their green card. Now you can go flip burgers or be the Microsoft CEO, as Rahul always says. So congrats. Keep letting us know when you receive your green card. That's always the best news for us. We'll be back next Tuesday. You can always subscribe to our newsletter at rnlawgroup.com or join any of our daily conference calls as well.
Thank you very much.